Good afternoon, everyone. You're all very welcome to this, the second in our series of webinars focusing on real estate and the built environment in light of the current COVID-19 crisis. Yesterday, for those of you who weren't on, we spoke about how it was affecting the residential sector in light of the new legislation, and today we're going to focus on the commercial landlord and tenant section. My name is Jamie Fitzmaurice. I'm a partner in our real estate department, and I'm joined by my fellow partners Oliver FitzGerald and Adam Hogg. Oliver is going to talk to us today about landlords and tenants, primarily in the retail situation, but also more generally. And then Adam's going to talk to us about the licensed premises, hotels and restaurants, and some practical tips that everyone can hopefully take away. At the end of it, we're hoping to have this as interactive as possible, and you'll all see on the panel in front of you, you can submit some questions. So at the end, we've allowed about 10 minutes for some Q&A. So hopefully you can feed those in and we'll put them to the panelists at the end. So without further ado, I'll hand you over to our first speaker, Oliver FitzGerald.
Thanks, Jamie. I'm going to talk to you today about the COVID-19 crisis and the retail sector. And in particular, I'm going to address three questions that I've been asked a lot in the last few weeks. They are, if we can move to the first slide, can tenants reduce, suspend or defer their lease payments? Can tenants close their store? And if tenants do these things, what can landlords do? Moving on then, just some background. Obviously, following the government's announcement on March 24th that all non-essential retail businesses were requested to close. Now, the definition of essential retail has turned out to be quite broad, with the result that we have a lot of retail establishments still open, perhaps more than we might have thought. Ireland is also somewhat of an outlier in a European context in that a lot of shopping centres remain open relative to our European neighbours. This is not ideal for tenants in that it means that they are the ones who have closed stores in many cases rather than their landlords. Moving on then though, but even for businesses that are deemed essential and can stay open, trading conditions and health and safety costs have meant that it just may not be financially viable. So ultimately, in summary, on the background, what we're left with is a large amount of stores closed. Moving on then, the question then is, what do tenants do? We should say at the outset, landlords and tenants can agree anything. There's nothing in the law or in leases that will stop them from doing that, so long as they get all necessary consents, for example, bank consents. One thing we should mention though in that context is that landlords should be very wary of setting the new market rent and thereby affecting future rent reviews both under the relevant lease they're varying and any other in the area. And we can assist you in advising on how to do that by documenting it carefully. Many tenants have also taken unilateral action and simply stopped paying rents or altered their rent payment in some other way. And you may have seen at the weekend, there was reports of in the media of the vast majority of rents in certain developments up to 94% or 84% not being paid. But what is the legal position? That's what we're going to look at today. Before we do that and we look at the three questions, there are some overall relevant considerations that should be considered in each case when we're looking at each lease, each situation. Firstly, the circumstances of the closure. Who closed the store? Why did they close it? Were they obliged to close it? So did the landlord close it? Did a tenant close it? Was it closed in compliance with the government requirement or request, or was it not? They will obviously be relevant questions. Another relevant item in each case is, what does the lease say? We know generally what leases say, but obviously each lease will vary even to a very minor degree from another one. And the one thing I'd mention in this context is to keep an eye out for license agreements, because they tend to vary a lot more between each other, and some of them can contain very unusual and potentially onerous provisions that might apply to store closures. Just keep an eye out for that. Moving on to the first question then, can tenants reduce, suspend or defer their lease payments? Our view on the basis of what we know of how leases are generally drafted and amended is that it's unlikely that tenants will be able to point to a specific clause in the lease that authorizes a reduction, suspension or deferral of rent. If the landlord, the best we can say is that if a landlord closes the property, the tenant may be able to make various claims against the landlord, such as, for example, breach of a quiet enjoyment obligation, breach of an obligation to provide services if there is one, breach of an obligation to provide access if there is one. And then they might also be hit with a claim of a breach of the doctrine of non-derogation from grant. This is a legal doctrine that says if you grant something, i.e. a lease, you can't then effectively take away from that grant by denying something inherent in it, such as, for example, access. Moving on then, I suppose it has to be said that these are not straightforward claims, and even, and they will be hard to establish in court. And even if there is a valid claim against a landlord, it's not clear that this would necessarily permit an unrelated tenant breach. Moving on then, please, Jamie. What about rent suspension for insured risks, uninsured risks, or uninsured damage? Well, insured risks clauses are almost always in longer term commercial leases, and they are in the landlord's draft generally. And as regards uninsured risks in modern commercial leases negotiated by solicitors from large firms, they will almost always seek an uninsured risks clause. The problem with these in the current crisis is that it's not at all clear that the current crisis falls within the definitions of uninsured risks or insured risks. It just wasn't designed to cover them. And even if it does, those clauses generally only apply where there is, to use the words that's generally used, damage or destruction to the property. And of course, there won't have been in this case. There just has been no damage as a result of this crisis in the strictest sense of that term. Moving on then, what about frustration of contract and force majeure? Well, frustration of contract is a legal doctrine that says if there's a supervening event not envisaged at the time of the contract that renders the contract impossible to perform, then the contract can be set aside or terminated effectively. Contract we're obviously talking about in this case is a lease. The problem with frustration in this context or in any context is, firstly, it's very hard to establish in court, and the general view appears to be that it's unlikely that this situation would, that the current crisis and leases would ground an action for frustration. Frustration also results in a termination of the lease, which may not be what many tenants will want. It would obviously suit some, but it won't suit others. Force majeure then is a similar concept that effectively releases parties from their contractual obligations in the event of some unforeseen event. The problem with force majeure is that in this situation for tenants is that unless the court implies a force majeure clause into the lease, which is very unlikely, there would have to be a force majeure clause for a tenant in the lease for a tenant to benefit from this concept, and they are very rare in commercial leases, very rare to non-existent, I would say. Moving on then to the second question, can a tenant just close their store? Well, this should be possible so long as the lease doesn't prohibit it, but it's important to say that just because a tenant closes a store doesn't mean the lease payment obligations will disappear. They will still be there, so it doesn't solve that problem. But what, moving on, is if there is a keep open clause, this is a clause which obliges the tenant to stay open during certain specified hours, and they're if not standard, then very common in shopping centre leases. Again, here we think a tenant would be in a similarly difficult position as they were to lease payments. And our analysis is roughly the same in that we think there's probably no specific clause they can point to. And though they may be able to make various claims against the landlord, depending on the circumstances, those claims will be hard to establish, and they probably don't permit a tenant breach. Should be noted that courts have been reluctant to order specific performance of keep open clauses. Specific performance is an order of the court that you must comply with a clause or a contractual obligation. And the courts have been reluctant to do that in the context of keep open clauses, and they presumably will be even more unlikely to do that in the current situation. So the landlord would presumably be relying on an action for damages there. Moving on to the third question I mentioned at the outset, what can landlords do if tenants stop paying or reduce lease payments? Well, presuming there's no legal ground supporting the tenant in what they did, that should constitute a breach of the lease. And if it does, the landlord will potentially have various remedies, including forfeiture of the lease, debt recovery proceedings, forfeiture of the deposit, a claim against the guarantor if there is one, a petition to have the tenant wound up. Moving on, it's just worth mentioning in the context of forfeiture that there are various potential issues there, and forfeiture is perhaps most likely to be the remedy used by landlords, or probably the most favoured one. The first thing to mention is that it may be impossible for a landlord to get a court order, at least in the short term, given the current limited availability of the courts. So landlords may have to, if they believe they can, peaceably re-enter, and some landlords may not be satisfied doing that without a court order. Also worth noticing that the tenant may be able to get relief against forfeiture. This is a court order that effectively the tenant can be relieved from the forfeiture action by the landlord. And again, the general view has been that courts have been relatively willing to grant relief against forfeiture in Ireland, and that's probably even more likely in the current crisis. Just to note, the emergency measures in the public interest COVID-19 Act 2020, which is obviously a brand new piece of legislation, was introduced, and it introduced a temporary ban on evictions, quote unquote evictions. Now, on the basis of the Dáil debates and on the basis of the fact that this was legislation amending the Residential Tenancies Act, we think it's highly likely that the Oireachtas intended to ban evictions of residential property only. Unfortunately, however, the drafting is sufficiently broad and vague that it could potentially be deemed by a court to prohibit commercial evictions. That's not our view of what they intended to do, but it is nevertheless a risk and an argument that a tenant may use against a landlord. So the big questions in retail now, or the big question is, what is the government going to do? How are they going to step in or are they going to step in to protect to help landlords and tenants? Are they going to offer loans to help tenants get through the situation? Are they going to institute some measure of burden sharing where landlords, tenants, and the government perhaps share an element of the lost rent? Are they going to explicitly and deliberately prohibit forfeiture? So those are the big questions. That is it from me for now. I'm going to pass you over to Adam, who's going to do the second half of our talk.
Great, thanks, Oliver, and good afternoon, everyone, and thank you again for joining our webinar. Just the purpose of my talk is to discuss some practical steps that business owners, particularly of hotels, restaurants, and licensed premises, may be able to take if they haven't already, with regard to safeguarding their cash flow and keeping their businesses alive. So just to touch on what I'm going to discuss briefly, the commercial rates deferral, business interruption insurance, new ways to trade, your supplier contracts, and then other sources of income. So just taking the commercial rates deferral first, again, very practical. Check what you've paid for 2020 so far. If you've paid the full amount, this doesn't necessarily apply to you, but if you haven't, is there scope for you to claim a deferral of what's to be paid to the local authority? So currently, the deferral period is stated to be limited to the end of May. We absolutely expect this to be extended, but you need to contact your local authority to find out and find out what's required. At the minimum, they should be agreeing a restructuring for you, but certainly the deferral period should be extended. Likewise, if you've got tenants in any part of your commercial premises, check, are they doing the same thing? So if in the future, if their business went under for whatever reason, you don't want to be liable for arrears in that regard. You want to make sure that they're taking similar steps as you. If the title to your premises is a lease, then you need to be approaching your landlord now, review your lease to see, is there scope to agree a rent-free period during the period of the crisis, or something similar, reduced rent, or change the way you pay rent from quarterly to monthly. If you paid a security deposit at the start, is there scope for your landlord to use that to be paid as rent in the short term? So again, be proactive, contact your landlord now. If you need legal advice about your lease, get ahead of it now and get in touch with your solicitor. And then just in terms of other costs and utilities to safeguard your cash flow, again, is there similar schemes or discounts that your utility suppliers are offering? If you don't ask them, you won't get it. So I absolutely recommend you do a list now and see and contact each supplier accordingly. Then the next area I'm going to talk about is the business interruption insurance. So check your insurance policy. Do you have this cover or not? Generally, you've got to check. The devil will be in the detail of your insurance policy itself. So do the insured perils include loss caused by communicable or infectious disease or similar specific wording? It has to be stated, and you need to possibly review that in advance of talking to your broker or insurance company with your solicitor if you think there's some ambiguity with regards to the interpretation of your policy. Insurance companies are or should be taking on board the Central Bank of Ireland's recent recommendation, which was confirmed by the Minister, that there's a few limbs to this, but basically that the government's advice to close businesses should be treated as a direction. The second limb is that CEOs for each insurance company will be held responsible for how they manage the determination of claims and their oversight with regards to paying claims in respect to COVID-19. The interpretation of any ambiguous terms or clauses in any insurance company should be read in favour of the consumer. Now, that's not a new principle, that's a long-standing contract law principle known as contra preferendum. So if there's any uncertainty about the way a clause is drafted, it should be generally held in favour of the consumer, depending, again, what your insurance policy says. There is precedent with regards to claiming business interruption insurance for infectious diseases. In Hong Kong, a hotel company group, Mandarin Oriental, successfully claimed 16 million due to business interruption loss in the context of SARS. Now, there's other precedent and a number of various other cases where people did not successfully claim due to the infectious disease not being notifiable at the date their policy was put in place. If they have a standard policy that only covers standard cover, again, may not be successful, but you need to look at your policy with your advisor to determine your likelihood. And then just separately, apart from business interruption, similar to what I said previously, your insurance costs are another cost, and you should be contacting your insurance company to get those reduced for whatever cover you currently need, whether you're trading or not. And Insurance Ireland have come out to say that they're exploring a range of flexible options to ensure their members are doing this. So they absolutely should be bearing that in mind. Then there's new ways to trade. So the Minister for Housing, Owen Murphy, recently brought in regulations to allow particularly food businesses provide takeaway and delivery services without the need to change their existing planning permission. So this is a novel way for restaurants and cafes to stay open and continue to trade to some degree while complying with their social distancing obligations. I expect this will create a new wave of online food delivery services. So I think the businesses who are quick to react and improve their online presence are going to benefit the most from this. By upgrading your website, consider what promotions you could offer compared to your competitors, and line up obviously your delivery service and how that's going to work. Similarly then, other new ways to stay open is hotels are offering themselves as isolation locations for the benefit of the HSE, and this is generally for people who have tested positive but don't require hospitalization but can't self-isolate at home. There's been some very good examples of this recently where City West have announced that their hotel itself can be used by medical care workers. I think they have 750 beds for that purpose, where those health workers can't go home because they can't mix with they have to stay separated from their family, obviously. And also City West, I think, have opened up their convention centre and converted it into effective a field hospital with 2,000 beds, which would be enormous help to the HSE. So there is potential for certain hotels around the country to look at themselves and consider, could we use our premises as an isolation location? And obviously that would have to be in consultation with the HSE and the government to see, can you now be reclassified as providing an essential service which allows you to stay open? Okay, then moving on. So your supplier contracts. So this is in terms of your existing cash flow and trying to maintain that and not paying out on supplier contracts unless you absolutely have to, or if it's absolutely required. And again, you need to consult with your suppliers on this to see, will they agree to vary whatever contracts are in place at the moment to possibly delay payments or agree variations. In terms of force majeure, that's probably the more extreme measure where you're looking to see if you can get out of a supplier contract. So for that, I think it was touched on earlier, you can't claim it unless there's a specific force majeure clause. You need to check each supplier contract to see, is that the case? This may only allow you delay performance of your obligations under that contract for the duration of any extraordinary event. So if you're not sure, based on your first review of the contract, discuss with your legal advisor. We have a webinar on this next Wednesday, which will be very useful, and we'll delve into this in a lot more detail. But it's probably one of the most important things you should be doing now before you contact your suppliers. And the ultimate goal is to avoid a claim for breach of contract, but maintain that relationship with the various suppliers for future business. Everyone only has one reputation, and it's a small market, so it's very important that you do that. And then finally, with regards to other sources of income. So again, regards to your cash flow and maintaining it and safeguarding what your cash flow is now, have you prepaid anything that you could claim a refund on? So something that you've paid for in advance that you haven't had the benefit of, could you seek that money back or a portion of it back for some reason? Talk to your accountant about potential VAT refunds or deferral of payments of VAT. I think the revenue commissioners have new schemes in place that your accountant should be aware of, so consult with them. Has there been, this more specific, but have you paid stamp duty on special exemptions for staying open late for weddings or events that you can seek a refund from the district court on? Again, negotiate with your customers who might have prepaid for events in your premises. Will they agree to receive a further discount as opposed to you paying them a full refund? And then more obvious, but have a look at the financial assistance packages offered by the government or lenders. I think more packages were announced today, and this is very much a fluid situation where there's measures being offered on a weekly basis. There's a number of grants also available from the likes of Fáilte Ireland, Board Bia and Enterprise Ireland. So check the various websites to see if you're eligible. We will send a list around after this webinar of what we think are useful websites in that regard that can give you support. And then finally, just in terms of my summary. So the key takeaways, there's real opportunities for restaurants and cafes to trade by delivery or takeaway. There's, we think, opportunity for hotels to open as isolation locations in consultation with the HSE, which would be a great help in terms of battling COVID and ensuring social distancing. We think you should review your costs and get advice from your accountant or your solicitor now to assess risks or opportunities, particularly with regards to suppliers and your existing contracts. Again, review financial assistance packages and grants. And then just finally, even though you may not be trading, you need to, as you know, keep your business ticking over, because I think we all expect there to be a bounce in trade when this is all over. So just to pass you back to Oliver, I think Oliver has some key takeaways as well he'd like to run you through.
Thanks, yeah. Just to go through the three questions I addressed on retail again. Can tenants reduce, suspend or defer lease payments on the basis of what we know of leases and how they are generally drafted? It's not clear that they can point to a specific clause that allows them to do it. They may, depending on the circumstances, be able to make various claims against landlords. But the tenant's case will be hard to establish and won't necessarily permit them to breach other clauses. Can tenants close their store? Yes, they can, so long as there's no keep open clause. And again, if there is one, they're in a similar position to where they are on lease payments. And finally, what can landlords do if tenants fail to pay? There are various remedies, but landlords should be aware the various issues with forfeiture that we mentioned above. Thank you very much.
Oliver, Adam, thanks very much for that. Very informative. A lot to get through there, I know. We have quite a volume of questions in. Hopefully some of them repeat themselves given the time we've allowed. I'll run through these as quickly as we can maybe. Oliver, Oliver, is there a positive obligation on landlords compelling them to reduce rent or otherwise, sorry, I add this for Adam actually, or otherwise reasonably engage with their tenants?
Right now, there is no statutory obligation for them to do that. It comes down to what the lease says and the interpretation of the obligations of each party with regards to the lease. Now, in saying that, if it went to court, the judge would absolutely expect and look for the landlords and both parties to be acting reasonably, particularly in the context of COVID.
Okay, thank you. A few of these along the same lines, Oliver. Can you run through why you think the new legislation does not apply to commercial evictions?
Yeah, so I mean, well, I suppose first of all, we can't say that really. I mean, it is the law. It is the law, and on the basis of the drafting, as far as we can see, there is a risk that it would be interpreted as applying to commercial tenancies. And the relevant points that make us think that it wasn't intended, I mentioned above. Firstly, the debates were clearly, they all focused on residential tenancies. There was no discussion of commercial tenancies. Secondly, the legislation is an amendment of the Residential Tenancies Act, so that would suggest that it was solely aimed at that, at residential tenancies. And finally, although this is in no way particularly definitive, the RTB have confirmed that it only applies to residential tenancies. So on that basis, we don't think it was intended, but it's not for us to say what a court's going to determine, having reviewed the legislation. So it is a risk still.
Thanks. Speaking of risks, there's kind of two questions here. I think, Oliver, you might take these as well. I'll run them together. Are landlords agreeing to variations in rent reductions, notwithstanding leases not specifically providing for it? And I suppose a second part of that question, if landlords do agree to it, are there risks that it might run again, or act, or not be in their best interest when it comes to a rent review?
Yeah, so I mean, the reality is, agreeing to a variation of the rent, and in particular a reduction, it's never going to be 100% safe from a rent review perspective. There's always going to be that bit of risk, but I suppose the way you deal with that is by making sure that you document it very carefully, and we can assist you with that. Obviously, the basic things you would want to do is make it very clear in the variation or the agreement that it's a temporary reduction for the purpose of assisting the tenant through this temporary disruption. It is not the market rent, and then you very explicitly say the tenant may not use this as evidence in a rent review. And I suppose if you're doing a number of them in relation to the same development, you might want to make sure that they don't get cross-referred. That each tenant is not allowed to use any other COVID-19 rent reduction as evidence in its rent review.
Great, thanks. Adam, is there anything else in your view the government should be doing to help hotels and licensed premises sectors?
I think there's a few practical things. Certainly, I know the VAT rate was relatively recently increased. I think they could bring it back down again for 2020, possibly bring it down to 9%. I think that would be reasonable. In terms of the commercial rate situation, as opposed to deferring, maybe they could agree to waive it for the year. I appreciate the local authorities need money, but that should possibly come from another government-based source rather than from local businesses. Aside from that, like, they do appear to be proactive, and there's government measures introduced, as I said, on a weekly basis. So we just have to keep reviewing them, and anything that's useful, make sure it doesn't sneak under the radar, and just keep reviewing them.
Okay, thanks. Oliver, if most of the tenants, presumably this is in a multi-let building, have ceased rental payments, what would you recommend for the landlord? To deal with them individually or collectively? I suppose that's not an easy one to answer without documents, but...
Yeah, exactly. I think we'd need to see the documents. We'd need to get an idea of the tenant profile, who you're dealing with. I mean, that is, that is the $1 million question, I suppose. Like, you would have to look at what you thought these tenants we're going to do after the crisis. I mean, some may have been in trouble before it and may struggle to come out of it. Others may be just solely affected by this crisis. Others may be doing well out of it. So, and then whether you approach them all individually or you do it all together, it's just going to be a commercial assessment based on all those analyses and looking at the documents as well, obviously. So happy to assist and review with that one, but we would need to look at it in greater detail. Okay.
I think we touched on this one a little bit. Could an unwritten break be used against a landlord at a later date? Sorry, actually, I read that question. I'm not, Clement, if you want to resubmit that question, we can try and get to it. I don't fully follow that question. We might come back to it. Adam, the Minister mentions that regard will be had to those flaunting the current guidelines around closure when it comes to publican renewals. Is there anything else that publicans should not be doing?
Anything they shouldn't be doing?
Yeah.
It's a tough question.
Yeah.
I mean, there's like obviously limited things they can do now if they're not trading, etc. So I don't know. I think leave that with me, and we can come back to the person who asked that question now.
Yep, perfect. Yep. If you want to email that in at the end.
Yeah.
Adam, if you, I might take this one if you don't mind. Are any of your clients setting themselves up as isolation units? Do you know if they're signing contracts with the HSE and what those terms look like? So I'm happy to take that one, Adam. So we've seen a number of clients do that in a number of guises, be it directly to the HSE, be it directly to providers of accommodation to frontline staff, or be it directly to frontline staff. And typically what we're seeing is, depending on the duration, if it's going to frontline staff, those terms are very, very, very light in terms of getting them signed quickly and not having much negotiation. So they're typically looking like caretakers agreements with fairly light terms in them. I.e. the frontline staff member is basically saying they will mind the property for the owner and give it back on demand, and that is their only obligation. If a number of units are being provided to an organisation, they typically are now taking the form, certainly that we have seen, of license agreements. Whether there's a license fee payable or not is completely a matter of commercial negotiation. Whether there's an element of service charge is a matter of commercial negotiation. But perhaps depending on who's in there, some of the things you might look at are cleaning provisions, deep cleaning provisions, etc. at the end of that. So hopefully that gives you a flavour of what we're seeing. So it's largely license agreements and caretakers agreements at the moment. Just looking through the next one. Oliver, are there risks to a landlord if it opts to close a property?
Yeah, there absolutely potentially are risks, and I think mostly they're the ones I mentioned above in the context of tenant payments. If a landlord opts to close the property, even if it does it in compliance with a government requirement or request, even more so, they are potentially exposed to claims that they've breached the tenant's quiet enjoyment obligation, that they've failed to provide services, that they failed to provide access. And then there's the doctrine of non-derogation from grant that I mentioned earlier on. So the reality is leases aren't drafted to deal with this situation. So landlords could potentially be exposed, and they should be aware of that.
Thanks, Oliver. A couple of similar questions here, Oliver, asking about any differences in position between retail tenants and office tenants, and whether you think the court would be more sympathetic to, firstly, is there a difference in your perspective in terms of how this whole approach to rent abatements, etc., closures might be dealt with? And secondly, would a court be more sympathetic to a retail tenant who was ordered to close and so stop paying rent, as opposed to, say, an office tenant who is, like us, working remotely from our living rooms?
Yeah, so I suppose, firstly, part of the reason we focused on retail firstly is because obviously there's been such a change there. But also because it is a better sector for displaying the legal principles behind this, because stores are just full on closed. They are not being used for the purpose that they were designed to be used for. They're shut. So that makes it a bit easier to to display the legal principles behind it. It's a lot more complicated with offices because, as Jamie just mentioned, offices can still be used. In many cases, even if nobody's in there, they're essential because they store things, they store data, and they store all the hardware that companies need to use, or in our case, it's largely closed, but you can still go in and access some essential documents or information. So I think the position on offices is quite different, and it's a lot harder to give a general view of how the courts would look at offices in general. You kind of need to look at each one and assess it. How a court's going to look at it is probably going to depend to no small degree on how the office is being used at the moment.
Thanks, Oliver. Conscious of time, and there's a lot more questions here to get through. I might just try and pick 2 or 3 of them. Another question, Adam, on the isolation units, and are we doing much of it? So we are, sorry, Adam, I might just take that off you. We are doing a bit. You might have seen 1 or 2 announcements on our website or on our news alerts recently. We did act for a particular client providing, I think it was 90 units. So that in those circumstances, and the client was providing those 90 units free of charge, and we had the pleasure of doing that work, and we didn't charge a fee for doing that work either. So we are seeing a bit of it. There's not a huge amount of it, but to the extent that some clients are feeling compelled or asked or feeling the need to help out, they certainly are doing it. So I certainly have 3 or 4 of them on the go, and I know other teams have 1 or 2 of them on the go as well. Adam, public and license renewals require tax clearance certs. If tax fall behind, do you think revenue will decline public licenses in August and September?
I think that they would be pretty, I don't think it would be very reasonable if they did. And I think the revenue commissioners are being proactive in working around and trying to provide various dispensations to publicans to allow, and other companies to facilitate the crisis. So I would be surprised if they took that approach. I think they have to allow and possibly push out the renewal requirement in the end of September, or do something with regards to that to make it more straightforward and allow for that tax clearance cert to be provided under separate criteria possibly. But I would be surprised if they did that.
Thanks, Adam. Okay, I think we have time for 2 more questions then. And for any questions we don't get to, we will have a list of the questions, and we'll try to come back to people if we can, or if they want to make direct contact with us. Oliver, the focus has been on rental abatements reductions. Do you think landlords should insist upon payment of service charges, or should they be dealt with in the same way?
Slightly different in that landlords may still be providing services, and it's not a pure profit element for the landlord. And security, for example, would need to be provided. Certain basic maintenance would need to be provided. So I can see an argument that it's different. Even if a landlord and tenant agreed that the rent was suspended for the period, I can see why a landlord would say that we should get a certain element of service charge as well. But I mean, it's all going to come down to a commercial assessment ultimately of, is this, the tenant's not trading, are they going to be able to pay anything? Almost, should it be all or nothing? And what we should charge them rent and service charge or nothing, depending on what view the landlord has taken. So again, that's one of those ones that's just going to depend on the situation, the commercial position of the tenant, what the landlord and tenant have agreed on rent and service charge generally.
Okay. Linked to that, Adam, I think the non-provision of services, I suppose if a landlord was not providing services, that would allow a tenant an argument to breach a keep open.
Absolutely, yeah. I absolutely think so, yeah. So, it's depending, again, it depends on what the lease says. So you need to review the terms of the lease in the first instance. So probably ignore my first broad response. Yes, you need to, so excuse that. So it depends what the contract says. So review the lease in the first instance. There invariably will be clauses in favor of the landlord with regards to provision of services. So each lease, each lease can have its own particular provisions. You need to review them. Okay,
I know I said it before, but final 2 questions now because I'm conscious of time. Oliver, We are finding that the request for a rental abatement can be an opportunity to do a re-gear and get some asset management done to improve/protect the investment. Obviously, the documentation of this will be key. Are you seeing much of this kind of activity?
Yeah, plenty of it. It's obviously, it's coming from both sides, and there's plenty of evidence out there in the market of tenants using this as an opportunity, tenants perhaps in a stronger position using this as an opportunity to fix issues they've had before, to improve their commercial position. Likewise, plenty of evidence of landlords doing that to fix technical issues they've had, to improve their general commercial deal in a longer term. So yeah, that's absolutely something we're seeing.
Okay, then I think, and then final question, Oliver, I think you touched on it previously already, but you might just elaborate a little bit. When a landlord offers a rental concession but doesn't actually document it in terms of amending or varying the lease, do you have a view on that? Is that more dangerous or for either party, or would you recommend documenting it?
Yeah, would absolutely recommend documenting it. Sometimes I think it can be, you can feel like saying nothing about it is a good idea, but the reality is everyone, ultimately in a rent review or in a court, it'll come out that the records will show that rent wasn't paid. And then if you haven't documented it, and I'm probably more talking about from a landlord's perspective here, but if you haven't documented it, the question will be, well, did you reduce the rent for that period? Did you waive the rent? And it could all get a bit unpleasant, and it could cause trouble on rent reviews. So I would recommend that it is well documented, carefully documented. It might be just a small reduction of rent for a few months, but it might have a big effect down the road if it's not properly documented. Okay,
Adam, Oliver, thanks very much for that.
Thank you.
I am very conscious that we haven't got to all of the questions there. There's 9 or 10 questions that we haven't got to yet. We have your questions, and if it's linked to an email address, we will make contact with you. But thank you very much, everybody. And we are going to be circulating both the links and the slides for this talk and yesterday's talk. They'll be out on Tuesday. There's also a request that you might fill in a survey based on these and let us know whether there's anything else you'd like us to cover in future webinars. I know, for example, next week we're hoping to do one on the construction sector. So please do take the time to fill out that survey and give us your feedback. But for the time being, thank you very much, everybody, for joining us this afternoon.
Thank you.